Okay, let's take a look at question 1 from 2013 February. It's criminal law. And let's go to the call to the question first. As always, if you have not read the fact pattern yet, please stop the video, read the fact pattern at least 3 times, just so you get a solid understanding of what's going on. So it's very important in order to get the full benefit of watching this and going through it, it's important that you are familiar with the fact pattern. Okay, now, assuming I'm on the bar exam, and this would be, let's say, assuming this is the first time that I'm reading it, go to the call to question. Like, you always go to the call to question first. In fact, one of the things I generally do, I like to draw a line through it so that you can see where the call to question starts, and realizing the fact pattern becomes so much shorter in that regard. Okay. It says, are Max, Alan, Bert, and or Carl guilty of A, conspiracy to receive stolen property? Now, it's interesting because a lot of people who are studying for the California bar exam, your friends, or if you've ever taken the bar before, you've probably done this, and you've quote unquote issue spotted essays. Okay, let me explain to you why that's one of the most ridiculous and one of the stupidest things you can do. They are giving you the issues. In fact, if you look at criminal law, criminal procedure, constitutional law, civil procedure, they'll actually give you specific issues they want you to discuss. Now, evidence and PR, totally different. That's a whole nother story. Issue spotting is what they're looking for in evidence. Okay, so let's go to A. And when the examiners put an A, you put an A. It's not that hard. Make it easy for the grader, and they'll make life a little bit easier for you. So, realize too, when we're talking about criminal law, the whole purpose of criminal law is to punish someone for having a guilty mind and acting on it. So it has to be act and intent. The entire focus of criminal law is focus on the defendant's intent. And how can you tell what the defendant intended? Well, in the real world, the prosecution is going to have to use inference and circumstances. On the bar exam, they're going to tell you what the defendant believed, or what the defendant, they're just going to say, the defendant believed this. Well, if he believed it, that's what he intended to do. So pay attention to the word believed. It's amazing how many times you'll see it now in criminal law. Okay, focus on the defendant's intent. Because each defendant is different, you're going to have to discuss them differently. So we have conspiracy for A, but we also have Max, Alan, Bert, and Carl. Would I discuss them separately? Unless, of course, there is a way to group them together. I would assume, and it's going to happen, you would discuss each one differently because each one is going to have a different intent. Okay. B, are Max, Alan, Bert, and or Carl guilty of receipt of stolen property with respect to the copy of the stolen painting? Okay, so receipt of stolen property. All right, and again, we're going to have Max, Alan, Bert, and Carl. And C, attempt to receive stolen property with respect to that copy of the stolen painting. So this is attempt. Here you go. Again, Max, Alan, Bert, and Carl. There you go. 3 issues, 4 defendants. There you go. Because you're going to have 12 different things to talk about, you realize some of them are going to be very quick. So I'm assuming, based on what I know, because I only have an hour to do this, and trust me, every essay is designed to be done in an hour. I love it. Oh, that was a racehorse. And it's an hour. You have an hour to do every one. That's what they're designed to be. So why do they go over the time limit? And the reason is because they discuss things that aren't there, because they can't spot what actually is there, and they go off in tangents. It's usually when they do checklists or templates or start repeating themselves in the essay. They'll end up going over time because the examiners aren't asking about that. Why are you discussing that? So understand what the exam, I know for a fact that somehow there's going to be somewhat of a consolidation in a couple of their intents. How do I know that? Because there's no possible way I'm going to have time to talk about 12 people, 12 different situations in detail. It's not possible. And I know this exam is designed to be done within an hour, so I'm going to have the chance to group them together. Here's another thing to realize. because there's so many calls in a sense, there's actually 3 calls, but like I said, 3 times 4, so there's 12. You know that what's going to be the most important call? The examiner's front load thing. So the most important thing is probably going to be an A and or B, and probably C is going to be the least important. I can already tell that's probably going to be the case. Okay, turns out A is the most, and then these 2 are kind of grouped together. That's why I don't want you to rush to finish. If you remember reading the essay tip sheet or the tips for doing essays, you will notice that spend the first 45 minutes doing the best that you can. Take your time, go through it. You're not going to do it slow, but you're also not rushing. And the last 15 minutes, that's when you wrap it up. Think about this. Let's say that you're going to an appointment. You got to be there in an hour. And you start off, you're not going to start driving recklessly to get there. Let's say the place is only a half an hour away. You're not going to drive recklessly the whole way there so you can get there 40 minutes early. No. What you do is you just drive regularly, you drive carefully, you drive according to the speed limit, et cetera, et cetera. Let's say there's a little traffic and now you have 10 minutes to get there. That's when you'll start speeding it up. But what a lot of students will do is they'll just hit the gas and they might get there on time, but they've killed 3 pedestrians on the way. So that's not what you want to do. If you're going to make mistakes, make it at the end. Take your time in the beginning. Don't rush to finish, because what it'll do is like now you'll have 25 minutes to answer and attempt, and you'll realize, oh, it's a 5-minute call. And you just wasted all that time here. And then you start throwing in random stuff here. You start bringing up murder. Nobody died, but you'll just, oh, well, I knew murder, so I decided to discuss it there. Horrible strategy. So that's one of the best ways to discuss how to do an essay. All right, let's take it from the top. Max imports paintings. For years, he has knowingly bought and resold paintings stolen from small museums in Europe. Okay, so he's a true businessman. Max, we know, is buying. So now, who is he agreeing with anyone to buy these stolen paintings? And he's received, well, any of these stolen paintings. Actually, the call B is respect to the copy of the stolen painting. Well, if it's a copy of the stolen painting, is the copy stolen? Because if the copy's not stolen, which is going to be hard to believe that a copy is stolen, probably the answer is going to be no here. And if it's no here, then they probably thought it was. You'll see how that works out. It's interesting how the call starts giving things away. If you really think about it, that's why you take your time to process the information before you start pounding on the keyboard aimlessly, and you wonder why you're having trouble with the essays. Okay. He operates a gallery in State X in partnership with his 3 sons, Alan, Bert, and Carl. But he has never told them about his criminal activities. Conspiracy. Okay, and don't forget, all conspiracy is an agreement to commit an unlawful act. An agreement is the gist of a conspiracy. You need the agreement. So the most important thing to discuss is, was there an agreement? There you go. Agreement and intent. There's the act. The act is the agreement, and the intent is the underlying purpose behind the agreement. So you have to intend to commit an unlawful act. You have to agree to commit an unlawful act. Okay. With the intent that it actually be committed. So agreement. Agreement is the essence of conspiracy. Remember that, because it gets tested on the MBs quite heavily. He has never told them. Each of his sons, however, has suspected that many of the paintings were stolen. Even though they suspected. Okay, so his sons suspect, never told. All right, show me the agreement in the first paragraph. You can look all you want. You can look for days. You're not going to find it. It's because there is no agreement. All right? So it doesn't look like there's going to be a conspiracy with Max and his sons. Unless, of course, the facts change. We'll see. One day, Max and his sons picked up a painting sent from London. Max had arranged to buy a painting recently stolen by Ted, one of his criminal sources, from a small British museum. Interesting, and the examiners cleverly did this. Notice they're asking about Max, A, B, and C. Nowhere does it say Ted, which is interesting because Max ends up having an agreement with Ted, and the examiners never even mention Ted here, which is a good, they really want to see if you're paying close attention to what's going on. And this is the difference between memorizing law and analyzing a fact pattern. People who try to memorize words on a page will fail the bar exam at a high rate. People that actually analyze a fact pattern and can think like a lawyer are the ones that are practicing law. So what do you think I want you to do? Start analyzing, thinking things. He doesn't have an agreement with A, B, or C. He's never told them, even though they suspect. That's not enough to get the intent requirement. But Max is he did enter into an agreement with T because they arranged to buy stolen paintings. So there's a conspiracy to receive stolen property. So Max and Ted have it from a small British museum. Max believed the painting they had picked up was the stolen one, but he did not share his belief with the others. So Max believes that they're picked up was the stolen one. Well, what did they pick up? We don't know which one they picked up yet. Having read an article about the theft, Alan also believed the painting was the stolen one, but also did not share his belief. Okay. This fact pattern is way confusing, by the way. So if you had trouble with reading it the first time, and you're like, wait, what's going on? Who's going where? That's why you have to read a fact pattern at least 3 times to iron this out. Okay, so it's interesting if you notice something too. The first 3 paragraphs really have to do with Max. The next 3 paragraphs, in order, A, B, and C. They tell you each what A, B, and C are up to. So guess who's going to be the most important call? Which one out of all the guys, out of all the defendants, is going to be the defendant that you're probably going to spend the most amount of time on? Max. Why? Because 3 paragraphs go to Max. 1 paragraph goes to each of these. They're probably going to be the lesser of the calls. Again, the examiners are not hiding the ball. This is a state licensing exam testing minimum legal competence. And if you can't see that, then you don't have minimum legal competence. My job is to show it to you so you can elevate that low bar that I call the passing line, and you can go ahead and start practicing law. And that's when things get fun. Okay. So, having read the article about the theft, Alan also believed the painting was the stolen one, but did not share his belief. Okay? Bert knew about the theft of the painting. Okay? And without Max's knowledge, probably no conspiracy, no knowledge, or didn't share it. Bert had arranged for Ted to send Max a copy of the stolen painting and to retain the stolen painting itself for sale later. Okay. So, Bert knew about it. When we talk about receiving stolen property, the painting that they actually received was a copy. So, if it's a copy of the stolen painting, it can't be receipt of stolen property. So the answer is going to be no, Bert, we don't know. Bert's a little question mark. And no, well, unless we don't see, but no one would seem to know about it. Attempt, well, as long as they believed it was a copy of the stolen, as long as they believed it was actually stolen, factual impossibility will not be a defense, which means that did they actually believe the painting itself was stolen? And the answer is yes. So attempt, they already said Max believed it, A believed it, so these two are going to be the same. So you can put Max and A together if you're really running out of time. If you aren't running out of time, separate them, but odds are you are. If anyone remembers the LSAT, the logic games, and you had to kind of put things together, this is kind of like what this puzzle is. It's just putting things together and figuring out what goes where. Because the facts aren't really that complicated once you iron out what's going on. C regularly sold information about Max's transactions to law enforcement agencies and continued to participate in the business for the sole purpose of continuing to deal with them. Okay, so C is working with law enforcement. You know, I can't wait to have a family someday. I mean, we got a father who's lying to his sons, who's stealing paintings. We have his sons all suspecting his shady father of running an illicit business. You got Bert who's screwing them all over. I mean, and selling the things they think are stolen behind their back. I mean, that's where I want to be this Thanksgiving. Okay, so let's talk. Okay, now that we have the fact pattern, you might want to go back and kind of look at a couple of things here. Are Max, Alan, Bert, and Carl guilty of conspiracy? So let's just take the conspiracy. Okay, so Max is in a partnership with his sons, but he's never told them about his criminal activities, although they have suspected it. Even though he never told them, there is no agreement. And granted, an agreement can be implied from the circumstances. And what does that mean? Two guys pull up to a liquor store in the same car, and they're both having sawed-off shotguns, they both have masks, and they both are in there demanding money. Yeah, you can infer a conspiracy under those facts, not under these facts. I mean, these guys are all double-crossing each other. You got this one working with law enforcement, this one trying to hoodwink all of them. Alan doesn't know what the hell is going on, but he suspects things. And Max is just the most crooked person you'll ever meet. So, but they never actually talked about it. There was no agreement between any of them. So, under common law, at common law, remember, it only had to be an agreement. That's it. Once there was an agreement, you had a conspiracy. Modernly, you need an overt act in furtherance of the conspiracy. And pretty much any act will do. Picking up the guns, getting blueprints of the facility, getting the ski masks, casing the place. That's an overt act. Why? Because that furthers the intent. It's easier for the prosecution to show that you guys weren't just talking, that you were actually serious about it, and that's how you prove intent in the real world. So, no agreement between Max and his sons, but Max did agree with T because they're arranging for the stolen properties. A read the article, but again, no agreement between A and T or A and M or A and B and A and C. So A, no intent, no agreement, no anything. B had no knowledge of it. However, B had arranged for Ted to send Max a copy of the stolen painting and to retain the stolen painting for itself for later for sale. So Bert has a conspiracy with T. Don't forget, Bert's double-crossing Max and Ted's double-crossing Max. Max is screwing everyone over. Well, it looks like Bert's going to get the last laugh because he's going to keep the stolen one for himself. So Bert and T have entered into an agreement to commit conspiracy to commit stolen property. And don't forget, you can be found guilty of conspiracy and of receiving stolen property. So there are two separate crimes. Here, they're actually being found guilty of conspiracy and receipt of stolen property or attempt to receive stolen property, depending on what whether or not the property was actually stolen. C is working with law enforcement, and also there's also no agreement, even if this was the unilateral. So common law conspiracy is what's called the bilateral. Common law is bilateral, which means it takes two parties to agree and two parties actually have the intent to agree. So let's say that C agreed with somebody but was working for the police. At common law, that would not be a conspiracy because it takes two to tango, and C doesn't have the actual intent. He's actually feigning the agreement by lying to the person in order to get them convicted with law enforcement. So it wouldn't be under common law. There wouldn't be an agreement under the unilateral conspiracy. Assuming somebody had an agreement with C, that person would be guilty of the Model Penal Code or unilateral conspiracy. Again, C would not be found guilty at all because C has no intent. He's working with law enforcement. Okay, receipt of stolen property in regard to a copy of the stolen painting. Well, M received a copy of the stolen painting, but it wasn't actually stolen. So no for M, no for A, because again, they only received a copy of it, no for C. So M, A, and C are exactly the same under this section. Now B, because it says a copy of the stolen painting, it doesn't retain its stolen status, it's a copy. Now if B later gets receipt from Ted of the actual painting, then he would be guilty of receipt of stolen property, but that hasn't happened yet. So this is going to be no for right now as well. And if any of this is a little bit confusing, once you read the answer will really explain it. So in addition to watching this video, definitely read the answer because the answer does a great job, the one-timers model answer that is, does a great job of really putting this all together. So the reason why it's going to be no under B for all of them is because the property has not retained its stolen status. And that brings us now to C. Because the property has not retained its stolen status, the question is, could they be found guilty of attempt? Now don't forget, every single attempt is a specific intent crime. So you must specifically intend the underlying crime. Well here, Max believed that he was picking up the stolen property. That's good enough for attempt. Same thing with A. A believed that it was the stolen one, so they're guilty of attempt. B knew it wasn't, so B is not going to be guilty of attempt. B completely knew. He didn't have the specific intent to acquire stolen property. Why? Because he knew it wasn't stolen. He knew that the copy was a fake, or whatever the case is. That's why Bert had Ted. Let's see real quick. The best way to explain it is that Bert knew the copy was not stolen. So Bert cannot be found guilty of attempt. And again, C, working with law enforcement, and his whole purpose was to foil the crime, so he doesn't have the specific intent to commit the underlying crime. And don't forget, attempt requires a substantial step, whereas a conspiracy requires an overt act, at least modernly. Because the examiners will sometimes test the difference between an overt act needed for conspiracy and a substantial step needed for attempt. Okay? Well, that pretty much solves this interesting dilemma on this fact pattern. Because it's a little bit confusing with all the parties, it's a good idea to do the best you can with organizing it in a certain way in terms of organizing your mind what's going on. But I would take each individual thing, A, B, and C. You could discuss each one of these. You should discuss M, A, B, and C here separately. For call B, you could actually put them all together. And that's why call B is so simple. It's like, no, because the property was not stolen. It never retained its stolen status. Here, with attempt, you put A and B together because they believed it was stolen. Therefore, they had the specific intent to receive stolen property. B had set the whole thing up, so clearly not for him, and C is working with law enforcement. So again, you can see calls B and C were super quick to get through. Call A probably would have taken some time. In fact, what would have taken the most time is reading the fact pattern carefully and fully understanding the question the examiners were asking you. All right, that's a wrap for 2013 February question 1 for criminal law.